Crime in Court. My name is Heather, and this is a stream about Alec Murdaugh. We're going to be talking today about the latest appellant brief from Alec Murdaugh's attorneys, or rather, I think it's only Dick Harpootlian who is listed on this brief, but regardless, we're going to read through that. And they're going to be asking for seeking a new trial with the Supreme Court. So, with that, I'm going to read through the appellant Richard Alexander Murdaugh's motion for certification under Rule 204B SCACR, whatever that is. All right, so pursuant to Rule 204B of the South Carolina, I'm going to shrink myself so you guys can see, of the South Carolina Appellate Court rules, petitioner Richard Alexander Murdaugh, through undersigned counsel, respectfully moves the court to certify this case for review before it is determined by the Court of Appeals. So they need it certified, whatever that means in the appellate courts. They need it certified in order to be reviewed and determined in the courts. All right, so this case concerns an issue of significant public interest and a legal principle of major importance warranting certification under Rule 204B. The issue of significant public interest is whether the verdict returned after Mr. Murdaugh's internationally televised homicide trial should be overturned due to unprecedented jury tampering by a state official, the former Colleton County Clerk of Court. And of course, that's Becky Hill that he's referring to. So, as you are probably aware of, Becky Hill, the Clerk of Court, was alleged or accused by the defense to be tampering with wanting the jury to have a specific outcome, and she was communicating with the jury members about their verdicts and trying to get the egg lady juror off the jury, things like that she's accused of. But there's also other misconduct on her end that there is now an internal investigations on her that is happening, and we still have yet to find out what's going on with that. So there's some ethical concerns about her. And she has resigned from her position as of, like, I think I don't know, last fall or something like that. All right, so the issue of significant public interest is whether the verdict returned, internationally televised trial. The legal principle of major importance is whether it is presumptively prejudicial for the state official to secretly advocate for a guilty verdict through ex parte contacts with jurors during trial. So she had one-sided conversations with jurors, or whether a defendant, having proven the contacts occurred, must also somehow prove the verdict would have been different at a hypothetical trial in which the surreptitious advocacy did not occur. So she was talking to people um outside of or to the jurors outside of her what can we get you for lunch type of conversation, and good morning, good night, you can leave now type of conversation. So she was talking to them about their actual verdicts. And even they're saying that even if it didn't change the verdict, it's still like their argument in the past has been, even if her conversations with the jurors and things like that didn't change the verdict, it still could have had a bias on the outcome of what the jurors then rendered for a verdict. So, all right, factual and procedural background. Mr. Murdaugh, once a prominent member of the South Carolina bar, admittedly stole money from clients, his law firm, and others to support a severe opioid addiction. His law firm confronted him with about his thievery on September 3rd, 2021. He resigned from the firm and after a failed self-deletion attempt assisted by his drug dealer entered drug rehabilitation. He was arrested immediately upon leaving a rehabilitation facility and has been incarcerated ever since. 3 months earlier, on June 7th, 2021, Mr. Murdaugh's wife, Maggie Murdaugh, and younger son, Paul Murdaugh, were brutally take their lives were brutally taken at approximately 9 p.m. at the dog kennels on their rural family property in Colleton County. That's the Moselle property. Mr. Murdaugh was indicted for the homicides on July 14th, 2022, and the trial commenced on January 23, 2023. So about a year and a half ago is when his trial took place, and it was about 6 weeks. It was a long trial, but um, Karen Reed was actually, I think, like 9 weeks, but they didn't go every single day, so it really drug out the trial. But anyways, all right. So Mr. Murdaugh was indicted for the homicides. Oh, I read that. Honorable Clifton B. Newman presided. He's now retired. The state claimed Mr. Murdaugh was confronted at his law firm earlier that day about missing attorney's fees and that he came home and took the life of his wife and son to distract a bookkeeper investigating these fees and to reduce his financial exposure in a negligent entrustment suit filed over 2 years earlier regarding a boat which Paul allegedly operated while intoxicated, resulting in the horrible loss of a young woman's life. So that was a long sentence. Let's break it down. Um, so the state's claiming, or they did claim in the trial, that Alec Murdaugh was, because he was being confronted about his financial crimes, that he went home and he took the lives of his children, or of his child and his wife, basically to distract the investigation and to um, reduce his exposure to his financial crimes, which I don't even know why that would matter. Like, okay, just because there's a horrific something that happens to you doesn't mean that you won't be charged for a crime that you committed before that happened. So like that already lost water for me when it was being presented at this, in trial that just because he was being confronted about his financial crimes, he would go off and do this to distract or deflect or whatever, which never made sense to me. So I'm glad that they're pointing that out here because it just doesn't make sense. All right, so and that was all because of the boat crash with uh, Mallory Mallory Beach, who lost her life that day when Paul was, it says, allegedly operating while intoxicated. It is most likely that he was the one driving or steering the boat. That is what all the other accounts said. But again, it could, you know, um, could have been something else, could have been someone else. We don't know, allegedly. All right, so Mr. Murdaugh admits all allegations of theft against him, but he vehemently denies taking the lives of his family. There is no direct evidence of Mr. Murdaugh's guilt. There were no witnesses to the crime, no videos or photos of the crime occurring, no recovered weapons, no DNA or uh, serology left on the scene establishing his guilt. As Judge Newman stated during trial, this is a circumstantial case, and it very much was. And I still don't know if Alec Murdaugh did it or not, but to me, State of South Carolina did not prove it. They, the story that they told us, it didn't make sense to me completely. There were a lot of holes. There's still a lot of holes that were never answered. So, did he do it? Did he not do it? I don't know. But I do know the state's case never made sense to me completely. So, as Judge Newman stated during trial, this is a circumstantial case. After 6 weeks of trial, the case was submitted to the jury at about 3:45 p.m. on March 2nd, 2023. The verdict was overturned early that evening. Jurors was not sorry, it was not overturned, it was returned. I think I said overturned. It was returned early that evening within like 2-3 hours. Jurors' television interviews indicate the actual deliberations took less than 1 hour, but they had a meal, so it took two. Mr. Murdaugh timely appealed the verdict. The appeal is separate from the that appeal is separate from the instant appeal, so they must have two separate appeal things going on. All right, so on August 1st, 2023, and the then Colleton County Clerk of Court, Rebecca Hill, published a book, Behind the Doors of Justice, about Mr. Murdaugh's trial. She had been planning to write a book about the trial even before it began. She repeatedly said that a guilty verdict would sell more books and that she needed to sell books because she needed a lake house. Oh my. Some people. All right. So the book caused some jurors to come forward to describe Ms. Hill's efforts to obtain her desired guilty verdict through jury tampering during trial. Jurors stated that after the state rested and the defense began its case, Ms. Hill entered the jury rooms often, telling jurors not to let the defense throw you all off or distract you or mislead you, and telling them not to be fooled by Mr. Murdaugh's testimony in his own defense. I don't care if it changed the what how if all those things that I just read are true, whether any of the jurors actually say, yeah, it changed my vote or didn't, I still think that it should be a mistrial and his charges at least should be recharged or retried. I think he should get a new trial. I do, based on a couple of things, not just the Becky Hill stuff, but also the fact that Judge Newman let in so much of the financial crime evidence that, I mean, I felt like we were at his financial crimes trial because that took up a lot of the testimony, and it made the was it supposed to be a 4-week trial? And it went 6 weeks or something like that. Like it extended the trial by a couple weeks at least. So, I just thought it was interesting that like he was there for it. He was like, if you would watch his face during testimony and things would come up about his financial crimes, Judge Newman's face would kind of like light up, and it almost is that if that like, yeah, give me some popcorn. I'm just enjoying listening to this, and I want to hear it. Like he would let everything in, which was interesting because we all wanted to hear it too. But in all fairness, I do think that he let way too much in. Anyways, that's just my humble opinion. And if she said these things, that don't let the defense throw you all off or distract you or mislead you, and don't let them fool you. Don't be fooled in Murdaugh's own defense when he takes the stand. That's crap. You can't say that. On September 5th, 2023, Mr. Murdaugh filed a motion to suspend his appeal and for leave to file a motion for a new trial based on the evidence of Ms. Hill's jury tampering. The Court of Appeals granted the motion, and Mr. Murdaugh filed his motion for a new trial on October 27th. On November 1st, he petitioned the court for a writ of prohibition to prohibit Judge Newman from adjudicating the new trial motion based on public statements Judge Newman made after the jury returned guilty verdicts. Judge Newman made some some comments that were a little unsettling that kind of made me feel like, well, he definitely is taking a side, and judges shouldn't take sides. On November 15th, the court denied the petition as moot because Judge Newman recused himself from hearing the new trial motion. That's because he was retiring. On December 18th, the Chief Justice appointed retired Chief Justice Jean Toll to serve as the circuit judge hearing Mr. Murdaugh's motion for a new trial. And I thought, I don't know, a lot of people liked her. I don't know. She was very like, don't waste my time, get to the point, get out of my courtroom. And I don't think she really gave it the attention that it deserved. So the circuit court ordered an evidentiary hearing and the parties submitted an extensive briefing in advance of the hearing. Appellants BR, what? Oh, I don't know what any of that means. What all of that says. So those are their exhibits. All right. So the circuit court held a pre-hearing procedure on January 16th, 2024 to determine inter alia, among other things that means, who has the burden of proof in this matter and what must be shown to meet the burden of proof and what must be then shown to contest what has been shown and proved. What? Okay, so their procedure or pre-hearing procedure was to determine who has the burden of proof in this matter and what must be shown to meet that burden of proof and what must then be shown to contest what has been shown and proved. I'm not here to be so philosophical. There's like, I don't know, right? It reminds me of friends like, they don't know we know, you know. At the pre-hearing hearing, the circuit court ruled that Mr. Murdaugh bears the burden to prove actual prejudice in the verdict rendered. It further ruled Mr. Murdaugh would not be permitted to call any witnesses, including eyewitnesses, to Ms. Hill's jury tampering or to examine any jurors called by the court. Yeah, I mean, she really limited things, Judge Toll did, and I don't think he had a fair shot at proving that the jurors might have been tampered with. Instead, the circuit court would call and itself examine each juror. So the circuit court, the only other witness would be Ms. Hill, and any cross-examination of her would be strictly limited. And that was a pre-hearing hearing. That's what they determined, I guess. All right, so on January 24th, the circuit court communicated its proposed questions to jurors to the parties. Mr. Murdaugh's counsel objected to the questions and to the rulings made at the pre-hearing hearing by letter dated January 25th, 2024. The circuit court reconsidered its prior rulings and allowed Mr. Murdaugh to call the alternate juror and Barnwell County Clerk Rhonda McIlveen and allow the parties an opportunity for cross-examination of witnesses who were not deliberating jurors. The evidentiary hearing was held on January 29th, 2024. A single juror testified one business day earlier, and we didn't see that one, but then we got to see the second day. So on January 26th, they had one business day earlier, so it was a Friday, January 26th, to accommodate a scheduling conflict. The other jurors, identified by anonymous letters, testified as follows. Jurors C, F, L, E, O, Y, W, Q, and K testified that they did not hear Ms. Hill comment on the merits of the case before the verdict. Juror P testified that he heard Ms. Hill tell jurors regarding Mr. Murdaugh's decision to testify in his own defense to watch his body language. A juror Juror P also testified the comment did not affect his verdict, but the fact that you heard it in- involves bias, and you might unconsciously give weight to what the clerk is saying versus um, somebody who isn't like in the justice system. You know what I'm saying? So just because she's a clerk, you might give her some more weight. So if she says watch his body language rather than just like any average citizen telling you that, if the clerk says that, it's like, oh, the clerk must know something. I don't know. Subconsciously, you might not make that connection consciously, but you might not knowing it. Juror X testified that she heard Ms. Hill comment regarding Mr. Murdaugh's decision to testify in his own defense that it was rare for a defendant to testify in a criminal case and that this is an epic day. Juror X testified the comments did not affect her verdict. Juror Z testified that she heard Ms. Hill comment regarding Mr. Murdaugh's decision to testify in his own defense, to watch Mr. Murdaugh's actions, and to watch him closely. Juror Z testified that the comments did affect her verdict. And when she said that, I was like, okay, there. Like, it did affect her verdict, but yet the judge didn't hear that or something. I don't know. So, question. All right. Was your verdict influenced in any way by the communications of the clerk of court in this case? Answer. Yes, ma'am. Question. And how was it influenced? Answer. To me, it felt like she made it seem like she was already guilty or that he was already guilty. Question. All right. And I understand that's the tenor of the remarks she made. Did that affect your finding of guilty in this case? Yes, ma'am. Mistrial. Call it, or not mistrial, but I think he deserves a retrial. That alone, right there. I don't know how that got overlooked by Judge Toll. It was just one of those things like, okay, moving on. Nope, you don't get a new trial. I ruled on it right here from the bench. Goodbye. It was like she wasn't hearing the answer read back to her. All right, so the circuit court then examined Juror Z regarding her affidavit attached to Mr. Murdaugh's motion for a new trial, and she affirmed each paragraph therein. The circuit court then asked, Juror Z, I asked you previously, was your verdict on March 2nd, 2023 influenced in any way by communications from Becky Hill, the clerk of court? You answer that question yes. In light of what you said in the affidavit, which is, I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. Is that answer that I just read a more accurate statement of how you felt? Mr. Harpootlian objected to the form. Court says overruled. Well, duh, because the court is the one asking the question, so she's going to overrule. You know, that's just not fair. And then answer, yes, ma'am. Question, all right, so do you stand by the affidavit? Yes, ma'am. Very good. And then after Jersey left the room, Mr. Murdaugh, counsel, objected. Mr. Harpootlian says, Your Honor, we objected to the questioning because this juror gave two statements under oath, one in an affidavit and one here to you today. The one here to you today was Becky Hill influenced her verdict. And that doesn't mean that she also didn't feel pressure from the jurors. Two things can be accurate at once. Two things can be true at once. Doesn't necessarily mean that um, only one happened. So stupid. Anyways, the court says yes. Mr. Harpootlian says the one she gave in an affidavit 6 months ago was based on jurors. It could be both. Your Honor picked out the one in the affidavit from 6 months ago and said, is that a more accurate statement? That presupposes and suggests to her what she should say. It really does. It's almost a leading question, or it sounds like you want a specific answer. And we believe that the juror's testimony, and Your Honor, I'm afraid what you're going to say is, well, she said the affidavit was more accurate than what she testified under oath here today, and therefore I am not going to consider her testimony. And I think that's what we're heading here. That's where we're heading here. I'd ask you to bring her back in, explain to her there's nothing wrong with it both being true. The court says I decline to do that and overrule the objection, which I think was wrong. And I think there's reason to appeal that. All right, so the court says I decline. Later, during the hearing, Juror Z, through her own counsel, provided an affidavit averring number one, I would like to clarify my testimony today. Two, as I testified, I felt influenced to find Mr. Murdaugh guilty by reason of Ms. Hill's remarks before I entered the jury room. Three, once deliberations began, as I stated in paragraph 10 of my earlier affidavit, I felt further additional pressure to reach the guilty verdict. Juror Z affidavit, January 28, 2024. Although the circuit court introduced Juror Z's pre-hearing affidavit into evidence on its own motion, it refused to allow Juror Z's affidavit of that day into evidence or to allow any further testimony from Juror Z. That's BS. To just cut it and not allow further explanation. And that is a really good reason for an appeal and for a new trial. Ms. Hill testified after the jurors. She denied engaging in any jury tampering. She also denied stating that she wanted a guilty verdict to promote book sales. She admitted she plagiarized portions of her book and that her profits from its sale in the 6 months before it was withdrawn from publication because of her plagiarism were approximately $100,000. She admitted the book contained unfounded statements included for poetic license or literary ease. Examination by the circuit court revealed that Ms. Hill's denial during direct examination of questioning a juror during the homicide trial was not truthful and that she did want a guilty verdict. So they're saying she lied. And she so easily lied. There were a lot of things that she was very not forthcoming with. Barnwell County Clerk of Court Rhonda McIlveen testified next to rebut Ms. Hill's denial that she wanted a guilty verdict to promote book sales. Ms. McIlveen was assisting in the courtroom during the homicide trial. She testified. Question. And did she discuss with you what, if anything, did she discuss with you about how she felt the verdict should turn out to be in the Murdaugh trial vis-a-vis in reference to the book? What would help the book? Answer, a guilty verdict. Question, tell the judge and me what exactly she said to you that you remember. This is prior to the trial. Answer, okay, well, first of all, she said we might want to write a book because she needed a lake house and I needed to retire. And from then, further conversation was that a guilty verdict would sell more books. And we left it at that. This was before, even in December. So it was before the trial even started. Question. And when did she ever say that again to you during the weeks you spent here? Answer, several times. It could be said it was, amongst friends in her office, or we might be having dinner, that kind of stuff, but that's about it. Question, that she needed a guilty verdict to sell more books? Answer, that would be the best way to sell books, yes, sir. Question, the best way to sell books. Now, during this process, did she ever express to you an opinion on whether or not, in fact, was Mr. Murdaugh guilty of the homicides of his son and his wife? Answer, yes, sir. Question, tell me what she said and if you remember when. Answer, I don't exactly remember when. I know it's over half of the trial had already happened, but the evidence was coming forth that it looked like he might be guilty. She made a comment that guilty verdict would be better for the sale of books. She also testified that Ms. Hill made comments to her like, don't be fooled by the evidence presented by Mr. Murdaugh's attorneys, identical to statements reported by some jurors. And she testified that Ms. Hill insisted on allowing a book writer who wrote the foreword to Miss Hill's book to sit in the well of the court during trial. So she allowed this guy who wrote the foreword of her book to sit in the court with her during the trial where she could see sealed exit she could show him sealed exhibits under the subterfuge of being a Sunday school teacher. What? She Let me read that again. And she testified that Ms. Hill insisted on allowing a book writer to sit in the well of the court during trial where she could see, must be a woman then that wrote the foreword. I'm thinking of the other guy that she was working with, the other writer, but I guess that's not who she was talking about. Um, so this woman would sit in the well of the court so she could see the exhibits, and that's not good. It was a reporter or a writer, sorry, a writer. All right, the final witness was the alternate juror, Juror 741. She testified that Ms. Hill told jurors the defense is about to do their side and they're going to say things that will try to confuse you, but don't let them confuse you or convince you or throw you off. Wow. At the excuse me. At the conclusion of the hearing, I need water. The circuit court ruled from the bench. Did Clerk of Court Hill make comments to any juror which expressed her opinion what the verdict would be? Ms. Hill denies doing so, and so the question becomes, was her denial credible? I find that the Clerk of Court is not completely credible as a witness. Miss Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed that as early as November 2022, 2 months before trial started, long before the trial began. She denies that this is so, but I find that she stated to the clerk of court, Rhonda McIlveen, and others her desire for a guilty verdict because it would sell books. She made comments about Murdaugh's demeanor as he testified, and she made some of those comments before he testified to at least one and maybe more jurors. So on the record, you have clear misconduct from the clerk of court with jury tampering. On the record, this is Jean Toll, retired Jean Toll, who they brought back specially for that hearing. She put that on the record. And then she goes on to say the clerk of court allowed public attention of the moment to overcome her duty. I think it's more than that, but okay. The circuit court nevertheless denied the motion. So even after saying all of that, they still denied the motion for a new trial, reasoning that there is no presumption of prejudice from tampering with jurors during a trial about the matter pending before the jury, and Mr. Murdaugh failed to prove that Ms. Hill's comments actually changed the jury's verdict. The circuit court discounted the testimony of Juror Z, who said that Ms. Hill's comments did affect her verdict because she was ambivalent in her testimony. That's the reason. So Jean Toll called her ambivalent in her testimony, which I don't think she was, and I don't think that she had any contradictory statements. It's just that Jean Toll took them as well. If one's true, then the other's not, but that's not the case. So, in a state drafted written order entered 66 days after the ruling from the bench, the circuit court further ruled in passing that the court also finds that any possible presumption of prejudice was overcome without any reference to any evidence presented at the evidentiary hearing. How do you know that it was overcome when one of the jurors just told you that yes, it affected her vote, her verdict? It's just ridiculous to me that she ruled that way after saying she's not a completely credible witness. I didn't find Hill credible at all, yet here we are. So, I don't know. Mr. Murdaugh timely appealed. All right, so on March 25th, 2024, Ms. Hill resigned from office. Okay, so it was March of this year. Sorry, I was wrong. In May 2024, it was report. I've been so into the Karen Reed stuff that I am not even like up to date on this or Idaho 4, but I'm trying to stay up to date on these for you guys. So on March 25th, 2024, Ms. Hill resigned from office. In May 2024, it was reported that the State Ethics Commission had referred ethics complaints against her for criminal prosecution. So she may be facing criminal prosecution for her involvement in whatever she was doing. There was misconduct going on, not just in the Murdaugh trial, but in other things where she was misappropriating funds and using her position to get things. So she's under investigation, and criminal complaints or criminal charges may ensue sometime. And that was in May that they announced that. So any time that they announce that they're pressing charges on or indicting her. All right, so legal standard. Rule 204B of the South Carolina Appellate Court Rules provides B. Certification by Supreme Court. In any case which is pending before the Court of Appeals, the Supreme Court may, in its discretion, on motion of any party to the case, on request by the Court of Appeals or on its own motion, certify the case for review by the Supreme Court before it has been determined by the Court of Appeals. Certification is normally appropriate where the case involves an issue of significant public interest or a legal principle of major importance. The effect of such certification shall be to transfer jurisdiction over the case to the Supreme Court for all purposes. So that's what they're trying to do, is get this to the Supreme Court, everything regarding this case. All right, so the argument, the circuit court erred when denying Mr. Murdaugh's motion for a new trial by ruling that South Carolina courts should disregard binding precedent of the U.S. Supreme Court. In Rummer versus United States, the U.S. Supreme Court held unanimously that in a criminal case, any tampering with a juror during a trial about the matter pending before the jury is, for obvious reasons, deemed presumptively prejudicial, and the burden rests heavily upon the government to establish that such contact with jurors was harmless, which they never went into. Why she talked to the juror. I mean, Becky Hill on the stand was very non-credible, and I didn't like Judge Toll's tone with the one juror, juror Z. All right, so the Fourth Circuit holds Remmer is clearly established federal law. The Circuit Court, however, ruled that State versus Green directs South Carolina courts to ignore Remmer. The South Carolina Supreme Court said very clearly, we do not go by the guidance of the 1950s case of U.S. versus Remmer. Mr. Harpootlian says that's, so this is a quote from Remmer, I guess, or from State versus Green. So Mr. Harpootlian was up against the court, whoever the court is, could be anybody residing, or presiding. Mr. Harpootlian says we do not believe that's what Justice Kittredge has said in State versus Green, and then the court says he said it straight out as clear as a bell can be, but I've ruled on that. So the court, however, has not split with the Fourth Circuit to instruct South Carolina courts to disregard Remmer. In Green, the court merely declined to adopt the Remmer presumption of prejudice in every instance of an inappropriate bailiff communication to a juror because not every inappropriate comment by a bailiff to a juror rises to the level of constitutional error, including the inappropriate comments at issue in Green, which did not touch the merits but dealt only with the procedural question of how the judge might handle a jury impasse that apparently never materialized. Green accords perfectly with recent Fourth Circuit authority under Rimmer. Any private communication, contact, or tampering directly or indirectly with a juror during a trial about the matter pending before the jury is deemed presumptively prejudicial, but to trigger the presumption, a defendant must introduce competent evidence of extrajudicial juror contact that are more than innocuous interventions. If the Rummer presumption of prejudice ever applies, it must apply here, as here an elected state official advocates for a guilty verdict in the jury room during trial so that she can personally profit from selling books about the trial. That is not an innocuous intervention. At the evidentiary hearing, the state failed to meet its heavy burden to overcome the presumption that Ms. Hill's conduct was prejudicial to Mr. Murdaugh's right to a fair trial before an impartial jury that considers only the evidence and argument presented in open court. It did not even try to argue any presumption was overcome. Circuit Court nonetheless held that Ms. Hill's jury tampering could not in any way undermine the fairness and impartiality of the 6-week trial, with the extensive evidentiary presentations, arguments from counsel, and instructions from the trial court, and any possible presumption of prejudice was overcome by these facts. That holding is both unsound and revealing. It is unsound in that it considers only the evidence against Mr. Murdaugh presented to the jury at trial, but not any evidence presented to the courtroom or to the court about Ms. Hill's tampering with the jury. So they're not taking that into account. It is revealing in that it shows the circuit court misapprehended the issue before it. The prejudice at issue, whether it is presumed or must be proven, is not an incorrect verdict. Jury tampering is prejudicial if it denies the accused a fair trial. The strength of the state's evidence against the accused cannot cure the denial of his right to a fair trial. Okay, next paragraph. But, right? What am I missing? But the present motion does argue the errors of the circuit court's decision. The motion merely argues that it decided a matter of major public interest and a legal principle of major importance, justifying immediate review by this court. On that point, Appellant and Chief Justice Toll may agree these matters are best disposed of by the trial judge in a very timely manner so that you may then go to the authorities that really count more than I do. This is the appellant authorities who will decide what the standard in this particular matter is. All right, so A, whether Mr. Murdaugh should be retried due to deliberate jury tampering by an elected state official acting for personal financial gain is a matter of significant public interest. Public interest in the Murdaugh case has been extraordinary. Mr. Murdaugh's trial likely was the most high-profile trial in the history of South Carolina. While there have been trials in this state for arguably worse crimes, those persons confessed to their crimes and were never prominent members of the community, and interests in their cases were more focused on the details of their horrific crimes than the operation of the resulting judicial proceedings. Mr. Murdaugh's case, however, has created intense interest in our state's judicial proceedings. Mr. Murdaugh is a fourth-generation son of what for over a century was one of the state's most prominent legal families, and he himself was once president to the South Carolina Trial Lawyers Association. For many South Carolinians, the interest comes from a strong desire to see justice served to a well-connected man who has only recently acknowledged lies and abuses of power that long went unchecked. James Pollard, what the Alex Murdaugh homicide trial says about the human psyche. LA Times, March 2nd, 2023. Additionally, the unusual, mysterious, sometimes bizarre, and continually evolving facts of this case have created unique interest in Mr. Murdaugh's court proceedings. Hold on, the dog needs a blanket. She's just being needy. Okay. She's a diva. We have a diva at home. How many of you guys have diva dogs? Additionally, the unusual, mysterious, sometimes bizarre, and continually evolving facts of this case have created unique interest in Mr. Murdaugh's court proceedings. South Carolina State Rep. Tommy Pope, who was the lead prosecutor in the Smith case, said he thinks people are drawn to the Murdaugh saga because of its truth is stranger than fiction aspects. It's like a soap opera, but it's really happening with real people, said Pope, adding, this is not entertainment, it is a tragedy, and lives were lost. Pope said the Murdaugh case offered an opportunity to educate the public about the justice system. As an analyst on Court TV during the trial, Pope said the gavel to gavel coverage probably helped viewers reach their own conclusions and understand the legal system's positives as well as its warts. Of course, Ms. Hill's participation in the trial turned out to be the biggest wart of all. I like that transition, that made me laugh. All right. It appears nothing like her misconduct has ever happened before. The cases cited in the circuit court's order involving external influences on jurors during trial dealt with minor things like a pamphlet left in the jury room or an alternate juror mistakenly and briefly being left with a jury after deliberations began, or one off inappropriate comments by bailiffs to jurors that did not directly relate to the merits of the case before them. None of those hiccups comes close to the elected state official in charge of managing juries engaging in deliberate jury tampering in a homicide trial to secure a guilty verdict so that she can make money selling books about it. I mean, it is pretty unique. I've never heard of this happening before. Ms. Hill's conduct was the subject of a hearing presided over by a former Chief Justice on live television. At that hearing, it was found that Ms. Hill planned to publish a book from the beginning, that she wanted a guilty verdict to boost book sales, that she did engage in jury tampering, advocating a guilty verdict, and she did subsequently publish the book for a profit of over $100,000. Ms. Hill has since been publicly accused of many crimes, some relating to the trial and others involving separate misconduct in office, and she has resigned in disgrace. But, as the circuit court stated at the conclusion of the hearing, the question of greatest public interest, whether Ms. Hill's unprecedented misconduct taints the verdict rendered in the highest profile trial in South Carolina history, has yet to be decided by the authorities that really count. That is, the appellate authorities who will decide what the standard in this particular matter is. And as Mr. Pope said, this case is teaching the public how South Carolina legal system deals with its warts. Does it cut them away, however painful it might be to cure them, or does it apply makeup to conceal them and learn to live with them? This is a matter of significant public interest for the court to decide. B. Whether it presumptively prejudicial for a state official to secretly advocate for a guilt verdict through ex parte contacts with jurors during trial, or whether the court has adopted the minority position in a federal circuit split in opposition to the Fourth Circuit to hold the defendant must also prove the verdict would have been different had the contacts not occurred in the legal principle of major importance. Additionally, the court should certify this appeal because it presents a legal principle of major importance independent of public interest in the facts of the case. Under Remmer, any tampering with a juror during a trial about the matter pending before the jury is, for obvious reasons, deemed presumptively prejudicial, and the burden rests heavily upon the government to establish that such contact with a juror was harmless. But the circuit court held that when there is tampering with a juror during a trial about the matter pending before the jury, prejudice is never presumed, but instead always must be proven by the defendant, which I think is a load of crap. On that issue, there is a three-way federal circuit split. The 1st, 2nd, 3rd, 4th, 7th, 9th, 11th, and DC circuits, and at least 28 states presume prejudice under Remmer, although many, like the 4th Circuit and this court appeared to do in Green, decline to apply it categorically to innocuous contacts with jurors. It is now well established that less serious instances of potential taint should be addressed during the abuse of discretion standard, with the presumption of prejudice being reserved for more serious instances. Um, 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 I apologize if you hear all that uh, sawing. My boyfriend's working on projects. He's making like coffins and stuff for Halloween. He's already made a few coffins for decorations for the yard where you can like hide in them and jump out at people. So pretty cool. Sorry if you guys can hear that. I don't know if you can, but it's loud to me. So all right. So notwithstanding the view of the, where are we? There are so many parentheses. I'm just gonna skip through them all. The question driving the split is whether Remmer was narrowed or overruled by later U.S. Supreme Court cases Smith versus Phillips and United States versus Olano. This is all like quoting different things, so it's really hard to follow this for someone who's not a lawyer. In Phillips, a juror applied for employment with the district attorney's office during trial, but the prosecution did not disclose the fact until after the trial. In Olano, the trial court permitted alternate jurors to attend but not participate in jury deliberations. That's weird. In each case, the Supreme Court held that a new trial was not required, but neither case involved an external influence on the jury from anyone other than alternate jurors. Both cases cited Remmer with approval, Olano and Phillips. Olano even stated there may be cases where an intrusion should be presumed prejudicial, citing Turner versus Louisiana as an example of such a case. In Turner, prejudice was presumed where the jury was in the charge of sheriff's deputies who were also prosecution witnesses, a fact pattern with a close similarity to the present case. The state never, like the deputies in Turner, Ms. Hill had the jury in her charge. She was not a prosecution witness, but like the prosecution witness, she made statements to the jury advocating a guilty verdict. All right. So the state nevertheless argued Remmer was abrogated by Smith and Olano. The circuit court agreed, ruling from the bench. I am not conducting a Remmer hearing. Remmer is a 1954 decision of the United States Supreme Court that deals with the question of influence of the jury and a motion for a new trial on the basis of after discovered evidence of that influence. I rely on the South Carolina decision of our Supreme Court authored by Justice Kittredge, State versus Green, and the Green decision specifically says that Remmer is not the guidance that South Carolina trial judges should look to in conducting hearings on after discovered evidence. All right, so in state drafted order, entered months after the evidentiary hearing, however, hides its reasoning, stating only that Murdaugh argues prejudice must be presumed under Remmer, while the state argues that the overwhelming weight of South Carolina case law is clear that the burden is on the defendant to show not only that the improper influence occurred, but also resulting prejudice. The order then proceeds to review South Carolina cases, some of which are arguably irrelevant, cases dealing with external influences, not touching on the merits of the case. Okay, blah, blah, blah. It's another parentheses. The order then proceeds to review South Carolina cases, some of which are arguably irrelevant and some of which are inarguably irrelevant, without attempting to explain why a U.S. Supreme Court decision on a question of federal constitutional law directly on point on the facts of the case is not good law. But the Fourth Circuit's contrary position could not be clearer. Some courts have suggested that post-Remmer developments, Smith versus Phillips, United States versus Volano, and Federal Rule of Evidence 606B narrowed or overturned Remmer's presumption of prejudice. United States versus Elbaz, certification was denied. This is so hard to read through all this stuff with all these parentheses. It's all parentheses. All right, so 2 years before the Fourth Circuit, Elbaz's decision, the most recent published decision affirming Remmer, the court in Green considered a case in which a juror asked a bailiff what would happen if the jury deadlocked, and the bailiff responded that the judge probably would give an Allen charge and ask them to stay later. The court held the trial court questioned each juror and the bailiff, which proved there was no reasonable possibility the bailiff's comments influenced the verdict. Our unwillingness to categorically apply the Remmer presumption of prejudice stems from our view that not every inappropriate comment by a bailiff to a juror rises to the level of constitutional error. In Remmer, a juror was approached by a person unnamed and told that the juror could profit by bringing in a verdict favorable to the defendant. The federal district court, without holding a hearing, denied the defendant's motion for a new trial. Ultimately, the Supreme Court recognized the presumption of prejudice from the highly improper juror contact and remanded to the federal district court to hold a hearing to determine whether the incident complained of was harmful to the defendant. The attempted bribery of the juror in Remmer conduct, which goes to the heart of the merits of the case on trial, is a far cry from the circumstances presented in this case. The bailiff's actions here, though improper, did not touch the merits but dealt only with the procedural question of how the judge might handle a jury impasse that apparently never even materialized. Circuit Court read that language to hold that South Carolina courts never apply the Remmer presumption of prejudice in any circumstances. Green is the only reported South Carolina appellate decision discussing Remmer. The question in the instant appeal is whether the court's Green decision indeed split from the Fourth Circuit and determined Remmer had been abrogated or overruled by subsequent cases. This is of major legal importance for at least two reasons. First, the circuit court's reading of the court's recent Green decision is plainly erroneous. While we decline to adopt the Remmer presumption of prejudice in every instance of an inappropriate bailiff communication to a juror, does not mean we decline to adopt the Remmer presumption of prejudice in any instance of inappropriate communication to a juror, nor does our willingness to categorically apply the Remmer presumption of prejudice stems from our view that not every inappropriate comment by a bailiff to a juror rises to the level of constitutional error, mean no inappropriate comment to a juror ever rises to the level of constitutional error. A more reasonable reading is that the court's opinion is identical to the Fourth Circuit's opinion expressed in Elbaz 2 years later. Prejudice is presumed unless the contact is innocuous or does not touch the merits. So that's a good way to combine the two ways of looking at it, is you should only you should presume that there is prejudice involved unless it is an innocuous comment in this case. That's what they're saying. All right, so that is also consistent with the earlier Court of Appeals decision in State versus Cameron, which held in this case there was the private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. When there has been such a communication, a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. In this case, I don't think it's harmless to say, watch him, don't be fooled by him, don't be fooled by the defense, watch his body language. That's not innocuous. Those aren't innocuous comments. It's not like, um, what would happen? It's not like somebody asks, what would happen in this situation? And then they're like, oh, well, we would have a hung jury or whatever. That has nothing to do with the merits of the case. So the circuit court refused to consider Cameron because it was a Court of Appeals decision. Mm, 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 mm. And because, in its view, the later Green decision held Remmer is no longer good law, but no matter how erroneous and unpersuasive Chief Justice Toll's reading of Green may be, her stature of as a jurist and the intense publicity surrounding her decision means her reading of Green is a uniquely precedential circuit court opinion that will guide South Carolina courts unless this court corrects it. Second, so they're saying you need to correct this before other courts can continue to do this, when other judges ruling in this way and this becoming the precedent. Second, a state splitting from its home federal circuit on a question of federal law is an issue of major legal significance, and doing so on a question of criminal law is especially important. It is so important it should only be done by the state's highest court after careful consideration. This court often defers to Fourth Circuit decisions interpreting federal law, but it is not obligated to do so. Where there is lack of uniformity against the federal circuits, Limehouse versus Hulsey, as noted above, there is a federal circuit split on the continued viability of Remmer. So, circuit courts, or federal courts, sorry, um, they differ, their opinions differ on how Remmer is the presumption that any comment, any extrajudicial comment to the jury is prejudicial. So this court is not obligated to follow the Fourth Circuit in the circuit split, but there are strong legal and prudential reasons to do so. Certainly, South Carolina courts are not required to follow the reasoning of the Fourth Circuit when it is an outlier, like children following the Pied Piper of Hamelin. But the Fourth Circuit's position accords with the majority of federal circuits and the majority of states. At least 35 federal appellate courts and state appellate courts of last resort agree with the Fourth Circuit that the Remmer presumption still applies to external communications with the jury during trial about the merits of the case before them. This court should join them. Although South Carolina's courts are not subjected to the mandate of the U.S. Court of Appeals for the Fourth Circuit, the South Carolina's executive officers having custody of prisoners in this state are subject to the writs of the courts of the Fourth Circuit. It's hard to read with all the courts, circuit, lots of hard consonant sounds. South Carolina courts must follow what the Fourth Circuit says it clearly established federal law regarding the rights of criminal defendants or federal courts. In the Fourth Circuit, will grant writs of habeas corpus. In other words, South Carolina courts are powerless to enforce their own opinions on questions of federal constitutional law in criminal cases where those opinions differ from the Fourth Circuit and splitting from the Fourth Circuit in such cases essentially in an act of advocacy. I have no idea what any of that just meant, but to the lawyers, I'm sure it made sense. If South Carolina believes the Fourth Circuit is incorrect on a question of criminal defendants' federal constitutional rights, it is better for South Carolina's Attorney General to convince the U.S. Supreme Court of that than to place South Carolina judges in the position of advocating against the reasoning of federal judges on questions of federal constitutional law. So they're saying it's not up to uh, judges like Jean Toll to go against what the federal judges are saying. Possibly the Attorney General would succeed, and this case would be the vehicle for overturning Remmer. Or perhaps the Supreme Court would decide Ms. Hill's egregious jury tampering does not present an attractive vehicle for changing the legal standard for a mistrial, because common sense says that when an elected state official goes into the jury room during a homicide trial to advocate for a guilty verdict because she wants to make money selling books about the guilty verdict, the result should be a mistrial. Absolutely 100% agree. I love that they keep restating that same sentence again because that is the important thing to remember in this motion, that a state official is alleged to have committed jury tampering. Not just that, but for a reason. Like she had a motive to sell books. So, I mean, there's a good reason why she did it too. Regardless, the Supreme Court is the proper court to decide whether most federal circuit courts have misunderstood Supreme Court precedent. South Carolina courts should follow what federal courts having jurisdiction over South Carolina have held is clearly established federal law and leave advocacy for changing that law to the Attorney General and his able deputy. So they're basically like calling Judge Toll out and saying like she's trying to change the law by setting a new precedent, but that should be set aside for the Attorney General or the Supreme Court to change the law. All right, so the circuit court's refusal to do so represents a legal issue of major significance necessitating review of this appeal by this court before it is determined by the Court of Appeals. Conclusion: for the foregoing reasons, appellant respectfully requests the court certify this case for review before it is determined by the Court of Appeals. And that is signed Richard Harpootlian and Jim Griffin, attorneys for petitioner Richard Alexander Murdaugh. There's a lot of mouthfuls. Not gonna lie, I didn't understand a whole lot of the appellate content where they talked about like the different cases and stuff, but I totally get the gist of it. And basically saying that Judge Toll ignored relevant evidence and testimony that could have given their client a new trial. It should have warranted a new trial, but she ignored it. She also stated on the record that Ms. Hill is not a credible witness, yet she denied the motion for a new trial. So now they're trying to take it up to the Supreme Court. They have some good arguments here. I really think that, and they're not even arguing about the whole letting all the financial crimes in. That might be a totally different motion that they'll have to do maybe in sometime in the future. But right now, they have to deal with the biggest elephant in the room, which is the Becky Hill jury tampering situation. The next largest elephant in the room is the federal crimes all coming into his trial and all of the, because it's 403B evidence that goes towards character, which Judge Newman said that the defense opened the door for character. and that's why it all came in, which I think was a bunch of BS, but I'm not a judge. I don't know. That's what happened. So, anyways, we are going to keep an eye on this. I'm definitely keeping an eye on this story and the Becky Hill story. I just might not always get a video out there if nothing big is breaking, if it might be like little things here and there. I don't always put things out, but this was a recent filing that just came out by the defense. So I wanted to make sure you guys had a chance to look it over with me. And if you have any questions, let me know in the comments below. Let me know what you think. Should Alec Murdaugh be given a new trial or not? Um, Let me know in the comments. Thank you guys so much for watching. Please hit the like button on your way out, and I will talk to you guys in the next one. Bye now.
If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.